Namaskar and a very good morning to you all. It's a proud privilege for me to come and deliver this lecture today. I'm grateful to the National Law University Tripura, the Vice-Chancellor, and especially Mr. Arindam Lodh, Justice Arindam Lodh, for giving me this opportunity. My tryst with Tripura would not have started if Mr. Apanshu Mohan Lodh had not fought for a separate High Court. So I am here because of it. So it's always, Tripura is like a second home to me, and it's always a pleasure to be back here. Honorable Justice Amarnath Lodh, Judge High Court of Tripura, Justice Arindam Lodh, Judge High Court of Tripura, my esteemed brothers, Justice U.B. Saab, Justice S.C. Das, and Satyagopal Chattopadhyay, Saktimal Chakravarti, Advocate General, Mr. Piyush Kanti Biswas, and Mr. Purushottam Roy Burman, Mr. Subrata Sarkar, senior advocates, and other members of the bar, members of the family of Mr. Apanshu Mohan Lodh. This was my only newspaper which I used to read, the local newspaper which I could read. Though within 1 year I had started reading a little bit of the Bangla papers also. I could read the headlines and a little bit of that because the news, there was hardcore news. Tripura has the maximum media concentration in Agartala than any other part of the country. Mr. Dr. Yogesh Pratap Singh, Vice-Chancellor of the University, and Registrar General, faculty members, Registrar General of the High Court of Tripura, and my dear brother and sister judges of this Tripura District Judiciary. Dear students, ladies and gentlemen, officers of the registry, it's always wonderful to be back in Tripura. When I had the good fortune of coming to Tripura and taking oath as its first Chief Justice on 23rd March 2013, one of the people who welcomed me was Mr. Apanshu. He was there when I unfurled the flag on 15th August. But he died, I think, in 2014 or 15? 14. I attended his funeral also. So the association with him was quite close. He was like a father figure to the entire judiciary of the state. And he encouraged me great words of wisdom. But since there has been the memorial, a very well presented movie on him, I don't think I can add anything more. So coming back to the topic of the day, when I was asked to speak, I have chosen the topic, rule of law and the role of the High Court. I have divided my address into two parts. First, what is the rule of law? Aristotle, the great philosopher, wrote, law should govern. It's a very simple statement, but what does that mean? Law should govern. Meaning that there would be a set of rules by which everybody should be governed. The citizens of a nation should be governed by law and not by the ideas of certain men or group of people. Otherwise, Professor Dicey is normally credited with introducing and propounding the concept of the rule of law. But one sees its applicability in various more ancient civilizations. I mentioned Aristotle from Greece. Even in India, we had a lot of kings who ruled according to Nyaya or who ruled according to Dharma. Both of them are also in a sense, rules of law. But the problem with these rules of law was that they were very individual-centric. One king could be very fair, could apply the law strictly in accordance with the law, but his son could be a despot who would say, I will do what I please. So there was no, and therefore when modern democracies came into place, it was felt that it is better to have a written constitution where the rule of law is embedded there. Well, not so modern, I wouldn't say modern, but the written concept of the rule of law finds its first manifestation in June 2015 in the signing of the Magna Carta. I think many would be aware, but just to enlighten you, King John ruled England at that time. The king was not a very powerful king. There were a lot of noblemen and barons who were fighting with him. The church was also an important part of the body politic in England, and there was a lot of tussle between the three. And the king, to fight his wars against his own noblemen, had taken loans from the King Philip, also the King of France. And he had to pay back the loans, so he increased the taxes. Now taxes are neither paid by the church, nor are they paid by the noblemen. They are paid by the poor peasants, who will pay it to the noblemen, who will give it to the king, or they are paid by the poor pious people in church, who will give it to the church, and who will give it in turn to. So then there was a lot of tussle, and there was thinking started, and then this concept started that why should we governed in this manner? Why can't we have a set of rules to govern? And thus the Magna Carta was signed. It was not a perfect document. But I would like to read two articles of the Magna Carta, which I find that even today's world, anywhere in the world, whether it is Ukraine, whether it is the US, whether it's India, they're relevant today also. And I'll quote two articles, Article 39 and 40 of the Magna Carta. Article 39 reads, and I quote, "No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land." So the king promised that I will not take any action against every one of my subjects unless it is prescribed by the law of the land and the decision is taken by his equals, his peers, which is the start of the jury system, as they know. So this was something this was the first time it was sort of written down. And Article 40 of the Magna Carta is also very important. And I quote it just one line, but probably very, very important, something which every judge should also revisit time and again. And I quote, "To no one will we sell, to no one deny or delay rights or justice." This simple one line embodies what a court's and a judge's duty is. To no one will we sell, to no one will we deny or delay rights or justice. You don't need 20 paragraphs, this one line says it all. But like it all happens after the signing of the Magna Carta, after we have so many judgments, things still don't proceed as they should. And this division led to a constant conflict in England between the church, the king, and the courts, or even parliament to a certain extent. Parliament was separate. In 1607, King James was the King of Britain, and Edward Coke was the Chief Justice. And at that time, Edward Coke passed one or two judgments. And I think I'll have to. Just, I think this. Yeah, this is the quotation I wanted to write. He wrote in one of the judgments, the law is the golden wand and measure to try the causes of the subject and which protects his majesty and safety. So what he said was that it is law which enables the king to rule peacefully. But the king took great offense to this because he thought he was incarnation of God himself, that he had divine power himself. And he removed Coke from the office of the Chief Justice. That did not stop Coke from still, he fought elections, he became a member of parliament and said, the king himself ought not to be subject to, but subject to God and the law, because the law makes him king. So this is really again a codification that law is above the ruler. Now, this is we come to England and now we come back to India. What is rule of law? The rule of law implies that every citizen is subject to the law. It stands in stark contrast to the idea that the ruler is above the law. The state and the citizen are absolutely equal. In the courts of law, there should not be two measures to judge the state or the citizen. They have to be treated equally. Though the phrase rule of law is now, it has many manifestations and many interpretations, I just want to set out a few. One is that law is supreme. The first and most important is that law is supreme. That nothing can be done which is not warranted by law. Rule of law also emphasizes an adjudication of law, an adjudication of disputes by certain fair measures, which we also call the due process of law, or in accordance with law. But the procedures prescribed must be identical for all and must be similar. Then the third important aspect of the rule of law is that discretionary power should be limited as far as possible. Discretion gives rise to great corruption. Discretion is the very antithesis of fairness. So, but finally, discretion has to be vested. Even as Chief Justice, you have the discretion to decide the roster. So, but then that, when the Chief Justice frames the roster, he must exercise his discretion in a just and fair manner. The doctrine of judicial precedent, so that there is some certainty in law. Not that today, if I go before Deepak Gupta, he decides it like that. If you go before Arindam Lodh, he decides it's another matter. So you have the law of precedent. We are all bound by the Supreme Court judgments. The district courts are bound by the High Court judgments. So that there is certain certainty in law. Not that law is, I am also not one of those who say law can never be changed. Law, but it should be changed at a drop of a hat. It should be changed only when there are very serious circumstances to change it. Normally, law should be prospective and not retrospective. In criminal law, we understand this very well. You cannot make something which is not an offence today and say retrospectively it will be an offence. That will never be upheld. Probably the only exception is tax laws, where they sometimes introduce retrospective to law, but normally laws should be prospective. Parliament, the exercise of power by Parliament should be the norm, and parliamentary powers should not be exercised by the executive. This is because we are a democracy and Parliament is the elected body. So all laws have to be framed by Parliament and the executive can follow the laws, see that they are followed, but it cannot be given such great discretionary or wide powers so as to make the laws itself. Then all laws must have a moral basis behind them. There cannot be an immoral law. And this has been recognized by our Supreme Court when we introduced the concept of constitutional morality. So there cannot be a law which is immoral. And the last, I said the first is most important and the last is equally important out of the aspects of, is a fearless and independent judiciary so that it is there to see that the rule of law is followed. Laws must be framed in such a manner that they do not affect the human rights of any human being. Even if the Constitution was not there, supposing there was no chapter on fundamental rights in our Constitution, I would still have held that there are some human rights which are inalienable. What today we call, say, the basic structure of the Constitution, which can't be amended by Parliament itself. So laws must be framed in a manner that they do not impinge on the human rights of individuals. And one of the most important of all human rights is the right of equality. All human beings must be treated equally and all laws must therefore be applied with equal vigor. And then, as I said before, everybody is the same in front of the law, whether it be the ruler or the citizen. Another very important aspect of the rule of law is that it implies there must be a provision for judicial review of administrative actions. So this is an inherent part of the rule of law, that administrative actions, otherwise administration actions cannot be challenged. We have the settlement-building principles on which limited challenge can be there. But the challenge has to be there so that finally it is the courts which will decide whether the legislature or the executive is acting according to the Constitution. Another very important aspect of the rule of law, especially in the Indian Constitution, is the separation of powers between the legislature, the executive, and the judiciary. The right to fair trial, the right to a speedy trial, these are all inherent in the rule of law. All laws must be published in such a manner that they are available to the citizens. We have this, ignorance is not an excuse for not knowing the law. But at the same time, you must take active action to see that the laws are published. My approach to the rule of law is very simple. In any society, whether we live in a family, whether we live in a small mohalla or a para, as you call it, in a small village, town, you have your own norms. You have your own set of rules. When you follow them, you are following the rule of law. When you break them, you are breaking them. So for me, that is a very simplistic approach, but right, taking it up and then it goes to the national level. As a principle of governance, rule of law like democracy and separation of powers is an integral part of the body politic, especially in the concept of the Indian Constitution. Anywhere, anytime, when ordinary people are given the choice, what would they choose? They will choose democracy over dictatorship. They will choose freedom, not tyranny. They will choose rule of law, not the whims and fancies of a few. The bedrock of a democratic way of life is the rule of law. If there is no rule of law, there will be anarchy, there will be corruption, subjugation, and indignation. A truly free and democratic country is one where there is freedom of expression and belief, and that flows from the rule of law. That, in my view, is the concept of the rule of law. Now, coming to the second part of my lecture, what is the role of the courts? My title says High Courts, but I would even go as far as to say it applies to virtually to all courts. The district judiciary may not be having the power under 226, but every day in and day out, and please excuse me, I'm not very familiar with the terminology of the new criminal code and the criminal IPC, the Bharatiya, I'm not, so I'll go with the old. पुराने पढ़े लिखे हैं वो भूलते नहीं हैं. See, when under the old section 167, you give remand, either police or judicial remand, you are taking away the fundamental right of liberty of any citizen in accordance with law. When you grant him bail, you are upholding his fundamental right. When a magistrate, sub-judge decides a property dispute between the parties, he is in a way deciding the rights to property under Article 300A of the Constitution. It's not that the district judiciary has no role to play. As I will talk to you later on, 99.9% people don't see the face of the High Court. For them, the judiciary is only the district judiciary. Whenever I talk of the role of the courts, I cannot but read out the preamble to the Constitution. It sits on my table today. When I was a newly appointed High Court judge, I went to Bhopal to attend a program, and at that time Dr. Madhava Menon was the director of the National Judicial Academy, and he gave us all a plaque, a brass plaque on which the preamble was written, and it still adorns my office. And I found that every time I had difficulty in deciding any matter, if I read and reread the preamble and then tried to interpret the law, I could find a correct answer. So what does the preamble say? We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. Now let's forget the word socialist and secular, because some people don't like it. Though according to me, even if these words are there or not there, it makes no difference, because secularism is embedded in the Constitution, even if it is not there in the empire. And not so much socialism, but what would you call fairness, equality is also embedded in the Constitution. What did we promise ourselves? Justice, social, economic, and political. So see, what is the first promise in the preamble to the Constitution? The preamble is the heart and soul of the Constitution. And what's the first promise? Justice, social, economic, and political. So that is justice for the highest level. Then liberty of thought, expression, belief, faith, and worship. Equality of status and opportunity. And lastly, something which is forgotten very often, and I keep reminding wherever I go anywhere to deliver a lecture nowadays, whether it's in a university, bar, or something, the one aspect which is not given so much, there are not too many judgments also, but for me that is very, very important, and that is fraternity, assuring the dignity of the individual and the unity and integrity of the nation. What is fraternity? Fraternity is what? Brotherhood. And if there is brotherhood, you do not divide people into castes, religions, divisions. These divisions have no place in a society which swears by fraternity of brotherhood. As far as I am aware, I think the South African constitution has a similar, slightly, but not such a wide provision. No other country in the world has a provision like Article 32 of the Constitution of India, which is a fundamental right, giving every citizen of this India, of this country, a fundamental right to approach the highest court of the land if his fundamental rights are violated. So the right to approach the smallest citizen in the country, sitting in a remote corner in some room somewhere, sitting in some room, he can go to the Supreme Court and say, my fundamental rights are violated. That is itself a fundamental right. That's the importance which our founding parents gave to the this fundamental right of approaching the courts. The importance that they gave to judicial review, that action should be approachable to courts. The high courts have been vested with the widest possible powers. Probably very few courts in the world have the wide powers which the high courts in India enjoy under Article 226 of the Constitution. I can, in fact, I have, maybe I won't say I'm an expert, there are teachers here who are experts, but I have read 8, 10 constitutions. I have not seen a constitution. I have discussed with lawyers worldwide. I have not seen a constitution where any court has been vested with so much power. We can set aside laws, we can set aside constitutional amendments, we can set aside anything. These sort of powers, most courts, we take from England. England can't do that. American courts can't do that. They just don't have this powers. French, in the common law countries, it's just not possible for the courts to interfere in executive actions also. Why were these wide powers given? To ensure that the superior courts, I don't mean that the district courts are any inferior, but superior courts in the term of superior courts being the high courts and the constitutional courts, high courts and the Supreme Court, act as guardians of the rights of the people. The role of the High Court is not only to decide disputes between parties. It is not only to decide disputes between individuals. It is not only to decide disputes between individuals and the state. It is not only to decide disputes between individuals and state and companies. It is also a very, very important role cast upon the High Courts is to decide matters and is to ensure that the High Court intervenes when it feels the rights of the people are either being taken away or what is due to the citizens is not being given to them by the state. It is, in my view, an obligation of the High Courts to intervene in these matters. And there is no excuse to say that there is no writ petition. I'll come to that in a later time. So we can have rule of law only when we have judges who can take decisions independent of any political influence. Some of you, I see Ruidas here, some of you who have been, when I was here as Chief Justice, used to get letters from me every year. That annual letter would come to every judicial officer. And I think even at that time I wrote to all of you that you should have no political sympathy. If you have, you may have, you see, I don't believe that before you become a judge, you may have political leanings. There's nothing wrong in that. But once you take an oath to act to the best of my ability and judgment, without fear or favor, affection or whatever, then all those political or even religious biases, political biases, social biases have to go away and you have to decide. After that, your only Bible, your only Gita, your only Quran, your only Guru Granth Sahib, your only Zed Avesta is the Constitution of India and nothing. Now, that brings me to the topic, what do the people expect from the judiciary? We've talked about the rule of law, we talked about the role of the courts, but what do the people expect from the judiciary? They expect that we get fair treatment at the hands of the court. They expect that we get a patient hearing from the court, that our pleas are listened to. A democratic way of life is totally incomplete without a high court. Rights will have no meaning if there is no high court to enforce those rights. आप लिख दो एक किताब के ऊपर कि ये आपके सारे अधिकार हैं, पर अधिकार कैसे प्राप्त करने हैं? How you will get your right? How will you don't have it? So then that is why the high courts are there to ensure that they get your right. No halfway house can be there. Other than the high court, there can be no halfway house. When one of the most eminent judges of India, Justice K.N. Vanchu, delivered a lecture in my parent High Court in the Himachal High Court, he said, no halfway house can take the place of the High Court. When we talk about democracy and how integral rule of law is to democracy, and then we talk of the Constitution of India. Now the Constitution of India is so many articles, so many chapters, but there's one golden thread which binds the Constitution together. And that golden thread is the rule of law. And the rule of law means fairness, equality, just behavior. And therefore, for the teeming masses of this country, they repose a lot of faith in the I think the amount of faith which the public in India have in they really worship Insaf ka mandir. They literally worship the courts. But do we live up to it? Do we live up to it? We have to think and introspect, think times are changing. And if we have to be relevant, we have to change with the times. We have to live up to the people's expectations. It is the judiciary which sends blood and oxygen in the form of rule of law to every extremity of the body politic. Constantly balancing individual rights with social interest and establishing every point the relationship between law and life. If Indian judiciary survives, Indian democracy survives. If the judiciary fails, it will be difficult for other democratic institutions to survive. That is the importance of the judiciary. And my request to all of you is please bear in mind this fact when you deal with cases or you deal with administrative matters. Now I've given my lecture on the rule of law. I have given my lecture on how judges, what is the role of the high courts. Now let me come to the practical aspect of it. When I came to Tripura in 2013, as its first Chief Justice, there were only about 7,600 odd cases pending. So then you may correct me if I'm wrong, but I think it was, I'm just off my hat.
Roughly 6,700.
Yes, 6,700. So I got the figure wrong, 6,700. When I left, there were about 2,500, 2,400. But for me, it is not disposal of cases which is important. Especially in a state like Tripura, where we don't have enough cases. Today I'm told there are only about 1,000 cases. So, and we have 5 judges, at that time also we were 5 judges. So, it's not just disposing of cases which is important. For me, what is important is the real justice being done. What is the quality of the judgments? And what is the reasoning given in the judgments? Which is very, very important. See, I am an old-fashioned judge. I still believe that judges should write judgments, giving reasons why they have decided certain matters. Each one has a right to decide differently. I am not into the merits of the judgments, the correctness of the judgment. But the judgment, the very word judgment means a decision based on reason. If there is no reasoning in the judgment, then It's not, I'm sorry to say, it's not a judge. The other aspect nowadays is we are so enamored with numbers that I disposed of 500 cases, I disposed of 200 cases, I disposed of 5,000 cases. That doesn't matter. To me, it doesn't matter. Did people get justice in those cases? That is much more important. There are many views. This is my view. I'm not saying others are not entitled to this view, but this is my view since I'm speaking here. I feel that when a litigant comes to the court, read his case. If you find no merit in his case, please dismiss it. Don't send it back to the authorities, make another representation or something. Don't do that. Because then he has to pay the lawyer another round of fees for this representation. And in my 47, 48 years in the profession, I have not seen any litigant getting relief from the executive. Those who have been unfair to him before will never be fair to him later. So, if you don't find merit in his case, dismiss it, relieve him of his agony. If you find merit in his case, give him full relief what he is entitled. Then don't hesitate. इसमें बहुत पैसे बन रहे हैं. Why should somebody get so much money or why should he get so much? Why not? If it's legal entitlement, he must get it. Then judges must be humane. See, I read the preamble. It talks of brotherhood, it talks of equality, it talks of freedom of thought and expression. These are about all aspects of humanity. You must be humane as a judge. You must put yourself in the shoes of a litigant. I come from a small state, Tripura, from Himachal. Tripura was even smaller than Himachal, exactly half the population, I remember at that time. Half the strength of the judges was also half. The bar strength was also about half. So it was half. But in the smaller states, we have a very big advantage that we have time. So the number of cases is less. So you could hear more cases. And I can tell you, neither I nor any other judge can deliver good judgments if you don't have proper assistance from the bar. And I'm not saying it because this is part of my written speech. And I received excellent assistance from the members of the Tripura High Court bar when I was there. For my 3 years I was there, I got excellent assistance. I delivered what I consider to be, in my own humble way, some of my best judgments in the state of Tripura. Not in Himachal or in the Supreme Court, but in the state of Tripura. Because there was less work and more time available, it was a pleasure to hear arguments at length, more time than I could devote in Himachal or anywhere else. And then decide the matters. People come to court because they have problems. Nobody likes to, barring 1% people who are cantankerous litigants, 99% people come to the litigants come to court because they're forced to come. Just put them yourself in their shoes and see whether they're entitled. So keeping these factors in mind, when I took over as the Chief Justice of Tripura, I felt that the greater responsibility lay upon me and my brother judges to decide matters with reasoned order. And with the support of my brother judges, 2 are here. Justice Talpatra is missing, but he also did a lot of hard work. And we could decide a lot of cases also. But more important than that, I think what I was successful in, what I take pride in, I was successful in generating genuine new litigation. Because if the courts will not give any relief, then no new litigation. It's not that relief has to be given if it is not warranted. It must be decided according to law. But if the judges are a little more liberal, then more cases come. And the institution rises. And if the institution rises, institutional cases rises, then the institution of the High Court can grow. One must also remember that for more than 99% of the people of the state, the High Court is the last court they can go. They just cannot afford to go to the Supreme Court. And therefore, I always felt when I was in this court that I should treat it as if this is the final court, so I should try not to make a mistake. Another aspect which I found was that though the literacy rate in Tripura was very high, I found the legal literacy was extremely low. Literacy in real terms was high, but people were not aware of their rights. And therefore the legal service authorities and all must be involved in making people aware of their rights. And if they are made aware of their rights, then things can change. Tripura is also a state where I think public interest litigation has an important role to play. And when I talk of PIL, I only mean public interest litigation. I don't mean publicity interest litigation. I don't mean personal interest litigation. But public interest litigation in states like Tripura is very important. So then especially, I'll just give a few examples. I don't want to be saying that I did anything extra than anybody else. But one of the cases I took up, I read a hoarding on the newspaper that school teachers were advertising that they will give tuitions to class 5 and 6 students. I said this goes against the Right to Education Act. Under the age of 14, nobody can be charged for any teaching. And I took it up as a PA and I decided it. Then another case where in the hospital there was news, probably in the Tripura Times or Shandan Patrika must have come the news that a patient died and the mother alleged negligence. We took up that matter, found that it was a case of negligence, and awarded 5 lakhs of damages in the public interest. We took up many other matters relating to witnesses. In Tripura, when I came, witnesses were never paid their diet money because they were told to come after 6 months to get the diet money or 3 months later. So then that also I took up on the legal side and decided that they must be paid. I mean, the dismal condition of the public toilets, the bus stands, the condition of the jails, the condition of the courts, all these were taken up in public interest. These are all, and can anybody say that they were not public interest? They were all public. So these were, what we gave to the people of Tripura was not something what Deepak Gupta did, something extraordinary out of the heart. I did not give them anything out of my pocket. I gave them, I did not force the state to give them what was not their need. I only directed that the state should give to the people what is their right under the constitution and the law and what is due to them under the constitution. And if that the courts can do, the public will have great faith in it. My wife Hon'ble and I spent 3 years in Tripura. These were the happiest years of our life. At a personal level, we spent more time with each other than we ever spent together ever. I had never seen so many movies with her than I saw, because on Sunday, every Sunday, I would see a movie with her in that big bazaar around home. Every Saturday or Sunday, we would go for a drive. I would be the driver, she would be my personal security officer, or vice versa, because we would not take a guard or anybody with us. And for 2 years, we haunted a dhaba near ICFA University, 828 dhaba. But until someday, 2 lawyers found out that we were there, and then that dhaba man never served us well again. And for what we did, the amount of love and affection we got from people of Tripura is immense. Before I part, I just wanted Justice Satyapal came to me in the morning, and while we were discussing, he reminded me of another case. He was the Registrar General, and he came up with a letter. And the letter said, the complaint from an old woman that a decree was passed in a river, she was executed. But one day after the execution, the mafia, उस time clubs बोलते थे, mafia, clubs that went there. They had taken over a court. We took that matter up also, called the police and restored the man to the lady. Yeah, upheld the rule of law. Because otherwise the FCC could have made a joke, क्या हुआ? The court has passed a decree, court has executed the decree, but we are more powerful. So that also, he just reminded me of the. But the most I can say is,
affection which I get here in the country is unbelievable. 3-4 months back, Prof had gone to Nehru Park in Delhi for a walk. Tripura Bubble is close to Nehru Park. And 3-4 healthy young people were walking in front of me. And I was a little very what is happening. And then one of them said, Deepak Gupta hai. I said, हाँ. I said, आप कौन हैं? We are from the Tripura police, we have come for some work. So I said, have you served in the High Court or how do you know me? He said, नहीं, हमने आपके साथ कभी काम नहीं किया, पर त्रिपुरा के लोग आपको अभी भी बहुत जानते हैं. That is a bigger compliment to me. And thank you all. Jai Hind.